Coercive control in the context of domestic violence in New Jersey has taken an entire different turn. Earlier this year in 2024, the New Jersey legislators passed through both channels and signed by the governor a new law that amended the Domestic Violence Act, which affects all of the restraining orders throughout the state of New Jersey. You see, plaintiffs in a restraining order case have to prove by a preponderance of the evidence a predicate act. Those predicate acts are in that first box in the first page of restraining orders that include assault, harassment, criminal mischief, stalking. There are various different crimes or offenses that qualify as predicate acts, defined as domestic violence within that statute. Once a plaintiff proves a predicate act by the preponderance, the court must then consider whether or not there's a need for the restraining order. It's called the Silver factors. And that is the second prong of the seminal case, Silver versus Silver. The amendment affects the second prong of the Silver factors because the court has to look to the history. The court has to look to whether or not there's any other orders from other jurisdictions, has to look to the children and whether or not there's custody issues. And now added to the list in the second prong is coercive control. Coercive control is a pattern of control. And there are some examples of coercive control in the statute. Financial control, not allowed to leave, false accusations to DCPP, law enforcement, or other agencies, affecting parenting time, orders. There's a list of them. And also the statute requires that judges issue written findings whether or not one or more factors of coercive control are found in the case. I've been on many panels discussing coercive control, and really what we're talking about is how it is going to change the scope of the evidence, because now this pattern of financial control and other controls could be admissible in the case, but also judges are going to be required to give written factual findings on coercive control, which is really the first. In the 10 plus years I've been out of the prosecutor's office handling domestic violence cases, I've only seen a couple decisions that have ever been in writing. Now with the amendment, judges are going to have to put it in writing. Does it really change things? It shouldn't, because even before this law change, they would have to take a look at the history and determine whether or not the plaintiff was in need of the restraining order. Here, it's just adding another factor to consider in that second prong for need, but there's a lot of attention on it. It's a conversation that we're having in the circles of attorneys. And certainly if you have any questions about coercive control, give my team of former prosecutors a call at the Bianchi Law Group. If you have any comments, drop them below. If you have any questions, give us a call, 862-210-8570, or visit us at bianchilawgroup.com, where you'll see a lot of these types of videos and other blog posts and articles about domestic violence. Hope you found this valuable. Take care.